learn from that experience, that despite the fact in that case that we had what I thought all our ducks in a row, and with some really good counsel on our side, we still ended up in a dispute. But fortunately, because we had our ducks in a row, because we had that good legal counsel, because we had that top auditing assistance, we ended up with no subsequent liability.
Hey everybody, my name is Imad. I'm here with founding partner of Anos Law, Peter Martino. How are you doing today?
Good, thanks, Imad. How are you?
Doing incredible. So we're here today to talk about observing corporate formalities and planning a business exit, right? I want to ask you, why is it important to observe corporate formalities as a business owner?
So you want the protection that's afforded to you by the type of corporation that you've formed, whether you're a C Corp or an LLC or whatever your corporate form is. And that's another area where I would encourage you to get some legal advice even before you form. But whatever your form is, there are certain rules that you need to follow in order to have the protections afforded to you by law. And you might ask, well, is this really important to have board meetings? Is it really important to document these things? Is it important to have minutes? Well, the answer is yes. And I'll give you an example. Right now, I'm defending a couple clients who are being sued for what's called piercing the corporate veil. So this particular party came after their company, and now the party is going after them as individuals, aiming to pierce the corporate veil, saying that corporation didn't follow corporate formalities and was an alter ego of the owners rather than an entity that needs and merits the protection of the law. So it's important in defending that, and any company can have that happen to them, is to show that no, corporation has been set up properly, that we have followed the corporate formalities, that we haven't commingled personal and business funds, or if there's an accounting for how that has been handled, so with correct policies and procedures in place, and that minutes are done and that meetings are had. Now, attorney can help with those things. I mean, you could put an attorney on your board, you could have an attorney at the meetings, you could follow up with your attorney afterwards and give the information. But I think that having a clear, documented set of formalities, it might sound boring, it's not the business of the business, it's not sexy, but it's really important for protecting the corporation and protecting the owners of that company from potential litigation at some point in the future.
Wow. Okay. And when it comes to agreements made, right? Do verbal agreements have any value there?
Sure, verbal agreements have value, but you always have to prove what the agreement is. I mean, an agreement, a contract, is a meeting of the minds. It's best to have that documented in some fashion so that you know what the meeting of the minds was. One of the problems with a verbal agreement is you could have two completely different versions of what people agreed to. So has there been a meeting of the minds if there's two versions? And, if you end up with a dispute, whether that just over the phone or whether it evolves to some sort of arbitration or litigation, what was that agreement? So I encourage you to, if you have business agreements, and they can be independent contractor agreements if you bring an independent contractor aboard. They can be agreements for a printing contract. They can be agreements for a social media person. They can be an SEO agreement. They can be an agreement with, somebody for any purpose in your business. Write it out. Make sure that you're on the same page. And then there are certain key elements of an agreement. Now, if you don't know them, if you haven't been to law school, or if you're not a lawyer, then get some legal advice. But if, as a minimum, you need to show that there's consideration, so that means that there's something for something. And there are other elements to make a valid contract. And we at Honest Law help organizations and individuals in formulating contracts to make sure they make sense. The thing I would say is don't necessarily just sign a form contract. You get a DocuSign that says that this is the way it is. Well, it doesn't have to be that way. You can, just because it's a DocuSign doesn't mean you can't change a term of a contract. And it doesn't mean that the contract has all the required elements of a contract. I mean, a contract is a contract, whether it's on paper, whether it's a DocuSign, whether it's in some other form. Let's make sure that it's what you envisioned on the business terms and that you have the legal protections that a contract affords you. So yes, to answer your long-winded answer to your question of, is a verbal agreement valid agreement? Yes, it is in many cases. In some cases not, such as not in real estate, etc. But the case of what does the verbal contract say is a harder one. So I would encourage you to write it.
Got it. Okay. So is it important to have any procedures for documents and retention?
Sure. Yes. So, every company has, as I mentioned, that, the originally on the minutes and meetings, et cetera, every company should have some sort of policies with regards to the retention of their documents, their corporate formation documents, their bylaws, their minutes of meetings, their emails. Many disputes that involve to litigation require people to ultimately produce emails, and the emails become a record. Well, for those of you that remember back, or if you read in history about the gap in the Nixon administration tapes, well, that's an example of people saying that there's something to be read into a gap. Well, just like a gap in, the Watergate tapes, a gap in your email records can also indicate to you that, hey, maybe something got deleted here. Maybe the person who's being sued in a particular battle purposely deleted emails in order to take to protect themselves in some way. Can give that sort of doubt and lead to questions, which might be even a jury question as to who's lying. Somebody says documents are deleted and somebody says they aren't. So I think it's important to have solid retention policies across the board for yourself and your employees that says when emails or other documents should be retained, when they can be deleted, and if there's some sort of schedule on your network, deleting emails automatically, to know what that is. Make sure the policy's sound. And then if there is a litigation event, then you have an obligation to retain those, and a lawyer can advise you on retaining those further. So, that it is an important part. It doesn't get a lot of attention, but it's an important part of the legal process. Documents. E-discovery or electronic discovery is one of the time-consuming and expensive parts of litigation. What I used to tell people is that the E in email stands for evidence. So, think about that, and think about the fact that generally just deleting an email doesn't protect you, because, emails are also like cockroaches. They live forever and they multiply, right? So, you don't know necessarily what's out there in cyberspace, but it's important to have policies in place that can protect you.
And so how would I go about, as a business owner, actually implementing this and making sure it gets done and followed through with?
Couple ways. So if you have a network administrator, if you have somebody in-house, you can set up an automatic system for the retention of certain email policies. You can put out written policies to your staff. You can follow certain policies yourself. You can have, back to the corporate formalities, you can have a different set of policies for people involved as your company secretary, if you have one, or something along the lines of retaining all the important resolutions, amendments, meetings, etc., that you have, so that you can prove that you're a viable company, that you're not an alter ego of the owners, and that you do follow document retention policies such that in the event that you do end up in a dispute, that what you're producing can be viewed with accuracy and not question.
Okay, it's really good. And so as business owners, we're often looking for exit opportunities. And so it's great when you think about it, like you're thinking about your exit and what you're building up and what you're working towards. But there are also a lot of times where people get into unwanted post-sale liabilities. So how do we avoid this?
Well, I think when you start your business and as you continue your business, you should run it every day as if you're going to sell it. So keep yourself as knowledgeable as you're going to keep a future buyer of your business in terms of company information. So that's from a business perspective. I really think, in having run businesses, I think it's really important to know your finances, to know your liabilities, to know exactly where you're going, and to be on top of that. That said, I think that most business owners look to that day when they're going to cash out, sell the company, have money for retirement. Kind of like heard the joke about boats. The two best days in the ownership of a boat are the day you buy the boat and the day you sell the boat. Sometimes in a company, it can be the same way. The day you start the company and the day you sell the company, because you may end up with some sort of windfall at the end. But it's important, and I think you'd be shocked to know the percentages, which are rather high, of post-sale problems that occur because there was a miscommunication or a misunderstanding what was being bought, what was being sold, or the liabilities or the assets associated with them, or the projections. So one of the parts of a sale agreement of a company or a merger agreement is called the reps and warranties, or the representations and warranties. And they are the statements of the seller stating everything that the seller represents about the organization that is being sold and everything that is warranted. I would highly encourage that legal counsel be employed anytime you sell a business, so that these sorts of reps and warranties get tailored to the specifics of what you're prepared to admit or submit to the buyer, and so that there's also comfort level at the buyer. So you have to make sure the buyer doesn't walk away because you're not repping and warranting enough, but you have to make sure that you're not exposing yourself to later claims against the sale. And that can happens quite frequently. So again, I think it's a key area. But if you've run your business well from the get-go, and you've maintained the proper procedures and done things right along the way, it makes it a whole lot easier when you go to sell. If you haven't, you can still clean things up before you sell. And again, you can get some help, and we do that sort of thing. You get some help in terms of selling your company, and you can get some legal help on the reps and warranties, and make sure that sale becomes a happy event and isn't one that you later regret.
That's amazing. Hey, look, so like we can cut this part out. Can I keep moving in? Can I keep moving in on this subject and ask you about what you've kind of experienced as far as post sale? Okay. So like, what have you seen? Like, what's some of the worst case scenarios that you've seen in post sale liabilities?
So I experienced one of those myself. Before I became a lawyer, I sold my first company when I was in my mid 30s, and I sold it to a public company in France. And at the time, we had sophisticated legal counsel, and we had sophisticated investment bankers representing us. In fact, at that time, and I know names change and organizations change, but I employed one of the big four accounting firms on my side, and the buyers had a big four accounting firm on their side, and everything seemed reasonable, and we closed the deal. Well, 12 months and 1 day after closing the deal, they sued us for a large amount of money in a French court, claiming fraud. And there was no fraud. But what they wanted was a price adjustment, because the performance of the company in that year after sale hadn't been up to projections. And one of the things that happens is when you have a company that sells a product, and then you have a new owner, that new owner can do certain things with the company in terms of what its revenue is going to be. In the case of the company I sold, we had 3 different revenue streams. The buyer canceled 2 of those revenue streams because they were competitive to products that they sold themselves, and then held the company accountable for not meeting its revenue projections after having canceled 2 of its revenue streams, and then sued for a price adjustment. That turned out where they got nothing, but it ended up costing a substantial amount of legal fees to get to a position where they walked away from that dispute. And it took 1.5 years. It really spurred me on to subsequently go to law school, and to learn from that experience, that despite the fact in that case that we had what I thought all our ducks in a row, and with some really good counsel on our side, we still ended up in a dispute. But fortunately, because we had our ducks in a row, because we had good legal counsel, because we had top auditing assistance, we ended up with no subsequent liability, although we ended up with a big legal bill to our own lawyers. So, but at least we made out far better than had there been any problems with what we had represented.
Okay. Everybody, that's Peter Martino on observing corporate formalities and planning a business exit. It's always amazing talking to him about this. Every week, Thursdays, we're going to be putting out an interview like this on subjects that business owners will be very, very, very interested in. You have anything else to say?
No, I'm good. Thanks, Aman. Been great talking today.
Great talking to you too.